Ladies and gentlemen, my name is Andrea Ostheimer, and I'm the representative of Konrad Adenauer Stiftung to the United Nations here in New York. It is my pleasure to welcome you to the discussion today, highlighting why women in the judiciary matter and how difficult it is also for them to establish themselves in leadership positions. Our discussion today is our second side event that CAS New York is hosting in the context of this year's Convention on the Status of Women, CSW66. In our strive to protect the rights of women, and particularly the rights of women from marginalized communities, we hosted last week a discussion on the rights of Indigenous women in the context of climate change. And for those of you who are interested in this topic, please visit the CAS New York YouTube channel. The recording will be posted there. Our second and today's discussion follows up on a discussion that we hosted last year with women judges serving on high courts. And the session today will provide us an opportunity to discuss the findings of the report by UN Special Rapporteur for the Independence of Judges and Lawyers, Diego García-Sayán. Diego García-Sayán had made the participation of women in the administration of justice a subject of his report to the UN General Assembly in October 2021. And when we look at women's full and effective participation and decision-making in public life, and the number of leadership positions they are holding in the judiciary, but also beyond, the situation remains dire and sobering. Women make up a mere quarter of national legislators worldwide, a third only of local government members, and just 1/5 of cabinet ministers. Only 22 countries are headed by a woman head of state or government, and at current rates, parity among heads of government would not be achieved until 2150. And I'm not saying 2050, I say 2150. The balance sheet in the judiciary does not look any better. Only 33.6% of women hold positions in Supreme Courts worldwide. And this trend is also mirrored in the proportion of presidential positions women occupy. On average, women hold 45.9% of presidencies in lower courts, 28% in courts of appeal, and 18.6% in high courts. And ladies and gentlemen, the data I have just given you goes back to an OECD analysis from 2017. And I find it already striking in itself that there is hardly any updated data available and out there. Cynically, one could come to the conclusion that the interest in the topic just remains low and not much progress probably could be reported anyway. Therefore, it is even more important to draw attention to the structural barriers within societies, but first and foremost also in the judicial system itself. And this is what we are trying to do today. And I would like to thank all of our panelists today, Justice Suzanne Glazebrook, Judge of the Supreme Court of New Zealand and President of the International Association of Women Judges, Justice Ayesha Malik, Pakistan's first female Supreme Court judge, and Diego García-Sayán, the UN Special Rapporteur for the Independence of Judges and Lawyers. So it's a pleasure and honor to have all of you with us today, and we are happy to provide the opportunity and to give insights into your own experiences and the kind of way you had to fight through the kind of glass ceilings in the judiciary system. I'm handing over now with these kind of welcome remarks to my colleague, Dr. Mónica Castillejos. Mónica is with us in the CAS New York team. She's a lawyer herself and works closely with the UN Special Rapporteur, and she's also our moderator today. Thank you very much. Mónica, over to you.
Thank you very much, Andrea. It is my pleasure to be here today to moderate this panel. My name is Mónica Castillejos, and I'm the program manager for the rule of law here at CAS New York. The discussion of the status of women's participation in public lives, as Andrea just mentioned, continues to be relevant, especially given the latest forecast provided by the World Economic Forum in its Global Gender Gap Report of 2020. This report analyzed 153 countries in their progress towards gender parity, and it calls for urgent action because it notes like it might take nearly a century to achieve gender parity around the world. And of course, this timeline, we can simply accept it in today's globalized world. But fortunately, to make sense of such challenge and to provide a more contemporary assessment, we have the analysis of our distinguished speakers. Our panelists will have 10 minutes to give their remarks in 2 rounds of questions. And without any further ado, I would like to start with Mr. Diego García-Sayán, who's the United Nations Special Rapporteur on the independence of judges and lawyers. Diego, you have the floor to present to the audience the outcome of your report. Diego, you are muted.
Sorry. Thank you, Monica. Really, thank you, Andrea. Really, I am very honored to have the possibility to participate in this panel. Really an honor as well to the possibility to share this conversation with Justice Glazebrook, a key person in the International Association of Women Judges. And my congratulations for Justice Ayesha Malik, a member of the Supreme Court of her country, Pakistan. 2 persons that really show that the strength, the will, and the possibilities of women in justice in a context which is very difficult. No? I will comment with you very briefly the main components of the report to which Andrea has referred, but it's impossible to avoid remembering that in the last hours, yesterday, an important women judge from Guatemala has had Lourdes Afiuni, a victim of different death threats and attacks because of her active role investigating big cases of corruption in her country, Guatemala. She has had to join many other women judges and women prosecutors that are living now in exile, most of them in the United States, considering that their strong activity, their brave commitment with the rule of law has generated a reaction in which perhaps if they were not women, the way in which they had been treated, the way they have been in practical terms expelled from their country and their institutions wouldn't have occurred. My homage to all of them, and of course, to many other women lawyers and judges that are being persecuted and attacked in different parts of the world, for not mentioning, of course, the case of Pakistan, to which, as rapporteur, I've had to present several communications to save the lives of judges and lawyers, women judges and lawyers in that country. So at the end of the day, I have to mention these facts, these dramatic facts, because the major question is, well, what is the place that women and women judges occupy in the judiciary in the world? The report I presented last year, I presented it to the General Assembly in New York, focuses on the importance of generating the conditions for women's access to the judiciary and the prosecution service to continue and encourage effective and not just discursive gender equality in the system of administration of justice worldwide. In the report, I examined the current status of women's presence in judicial systems, identifying the main barriers to women's adequate access, promotion, and retention in the judiciary and the prosecution services, especially in its high levels. This is a big, broad matter, so that to receive information, to identify the main challenges, I circulated a questionnaire that was responded by states, international and human rights organizations, lawyers and judges organizations, as professional associations of women, judges and prosecutors that gave me a big amount of information and very valuable elements for analysis. But at the same time, I organized and we received a strong support from Monica Castillejos in this process, different regional meetings with judges in Europe, Latin America, United States, Canada, and Africa. It was really astonishing to find, bearing in mind many differences, of course, because of the way in which the judiciary is organized and so on, the way in which a lot of similitudes that eventually you can say what is happening in Norway and what is happening in India or what is happening in Brazil is very, very similar. In most cases, for not saying in all of the cases, there is a kind of pyramid that is very, very tiny, small in the top, in which for women, it is very difficult to have access to that high levels of the judiciary in all countries, even the countries that we can imagine the perfect countries in the Nordic area, in which the same difficulties, the same challenges were found after witnesses that we receive in this meeting. The core finding that runs through the report is very clear and fundamental. Gender equality in the administration of justice continues to be more a discourse rather than a reality. Despite international campaigns, discrimination against women in the judicial system, it persists. The data collected show, however, that the general trend in recent years has been of a gradual increase in the number of women in the judiciary and the prosecution service in their lower and intermediate levels. In some countries, women even outnumber men in the number of judges and prosecutors. Europe leads in this matter with an average of 54% of women, followed by the Americas with 51%. This data begins to reduce in Oceania, Africa, and Asia to Asia to 31, 30, and 29% of the total. I can give the example of my country, Peru. Half of the judges are women, and but in the first time of Republican history after 200 years of independence that we have a Chief Justice, which is a woman, the first time, and after her leadership, the first time as well that we have 50-50% in the Supreme Court in Peru because of her leadership, because she is a woman. It's the first time after 200 years. So we can imagine different figures, different examples all around the world. But at the end of the day, there were three main points of concern that I raised in my report following the data obtained, the questionnaire and what we receive in these regional meetings. First, that as one moves up in the career ladder, the number of women in managerial or senior positions is decreasing. This is a consistent global trend in Supreme Courts, constitutional tribunals, or prosecutor general, with very few exceptions. Second, the fact that gender prejudices and stereotypes continue to affect women, especially in terms of assignment. And this is a worldwide phenomenon as well. Women are more assigned to certain jurisdictions simply because they are considered to be women's courts, such as family, labor, peace courts. This, unfortunately, is as well a generalized tendency. In the case of Guatemala, all these prosecutors and judges that have been involved in tough in cases against corruption, all of them have been expelled, all of them are now living in exile. Third, the conditions of work and promotion within the judicial and prosecutorial careers tend to have a differentiated impact on women with a lower economic capacity or who have to combine their work activity with their lifestyle and family responsibilities. This is the case, for example, with a requirement of higher education beyond a bachelor's degree or special training courses for promotion that it requires economic resources, which not everybody has, and much more time outside working hours in which very few women eventually have available. Women are always at a greater disadvantage than their male colleagues, unfortunately. The problem thus lies in the unequal or scarce implementation of appropriate measures by the states that have to do not only with the justice systems, with general politics, general standards of how public institutions work, because they are well-known barriers that led not only the judiciary to underrepresentation in high-level public decision-making functions for women, in confining women to certain areas that are considered more for women than for men. The lack or weakness of explicit and sustained public policy in this area, of political will, and of strong institutions within the state to promote and monitor this kind of participation of the women policies harms the judicial system because they lack of an equal presence of women at higher levels. In several countries, significant barriers still remain in several areas. As I stated in my report, there is a greater risk for women judges and prosecutors to suffer aggressions or different forms of harassment in the workplace or sextortion as well, as the International Association of Women Judges has called it. Gender stereotypes facilitate the harassment and violation of the personal integrity of female judges in several situations, taking advantage of the anonymity provided by new technologies and on occasions with the connivance of a public opinion that is mostly dominated by men. Regardless of the region in which they are located, female judges have reported being victims of workplace or sexual harassment at some point in their careers. Nevertheless, I must acknowledge as well the efforts being made in several countries to correct the effects of these stereotypes in the judicial system. I have just made a concrete, very precise example of my country, Peru. It has been possible to identify the adoption of different measures, such as training programs in gender perspective, or the inclusion of the gender perspective in law school, which is a new phenomenon taking place in different parts of the world. The limited presence of women in high courts and leadership positions in prosecutors' offices is a major and generalized pattern at the global level. Even in those countries where there is equal representation of the sexes in different courts, as one moves up the ladder, the percentage of women judges decrease significantly. This reality must be transformed because it violates human rights. Urgent measures are needed to ensure equal conditions for access to higher courts so that equal career advancement is achieved. Above all, it is necessary to guarantee a work-life balance that makes it compatible to assume greater professional responsibilities with family responsibilities, a deficiency that in many occasions constitutes an structural causal factor of a lower presence of women in the higher courts of justice. Dear friends, dear colleagues, for closing my presentation, I can mention some of the recommendations that were presented in my report. I will reduce it now to 7 recommendations. First, within the framework of the Sustainable Development Goals, every effort should be made to ensure that by 2030, 50% of senior positions in the judiciary are held by women. Second, design and implement a quota system that is not merely symbolic to ensure equality in entry to positions in the administration of justice and to achieve greater equality from a geographical or regional perspective. Quotas so to guarantee that this 50% can be achieved in the following 8 years. Third, create, when it doesn't exist, a public, autonomous, and independent institution that coordinates public policies, not only in the judiciary, on equality and gender perspective, and is complied by all public entities adopting for this purpose norms, public policies, and quantifiable goals. Fourth, review the formal requirements for entry or promotion in the judicial career so that the so-called glass ceiling does not persist, and there are no bureaucratic barriers that hinder women's access to high positions in the judiciary. To this end, I recommended that competition be held specifically for women, especially when the courts are composed only of men or majority by men, and when there is a higher percentage of female judges. Fifth, eliminate stereotypes that pigeonhole women in specific areas of law or at certain levels in the judicial hierarchy, such as family law, or at the lowest level of the judiciary, such as peace courts or provisional courts with no guarantees of employment or tenure. Sixth, encourage the strengthening and where appropriate the creation of association of women judges and prosecutors that strengthen the participation of women in the judicial career, defend their rights, and enable them to participate in the adoption of policies to promote gender equity in the judiciary and the prosecution. Congratulations to all the activities and programs being promoted by the International Association of Women Judges, and by the way, Justice Glazebrook. And finally, 7, the gender perspective must be assumed as a fundamental articulating criterion, as well as a method of reasoning and objective and rigorous analysis that identifies, eradicates gender stereotypes that plague the courts and prosecutors' offices, and that assumes the gender perspective as an inescapable duty of the state to be sustained not only by women judges, but by all judges in the judicial system. So let me finish with this, and perhaps I have exceeded the time assigned for me, but that's a summary. Perhaps that may reduce logically my next presentation, but I will enjoy to receive from my colleagues here criticisms, questions, and of course, much more experience, ideas, and views than the ones I have presented and summarized today. Thank you very much.
Thank you very much, Diego, for your presentation and for engaging in a rather relevant discussion to further identifying conditions and providing relevant data about access of women judges to higher offices within the judiciary and the prosecutorial offices around the world. And now I would like to continue with Honorable Justice Susan Glazebrook, who is the president of the International Association of Women Judges, and she's also a justice at the Supreme Court of New Zealand. Justice Glazebrook, the data analyzed by the UN Special Rapporteur, as he just presented, shows that there is a general trend in recent years that has gradually increased the number of women in the judiciary and the prosecutorial services. However, gender bias and stereotypes continue to affect younger women judges, as they are often assigned to certain jurisdictions, for example, those that are considered socially oriented. And this is a widespread trend with a few exceptions. And for example, the UN Special Rapporteur in this document demonstrates, like for example, New Zealand, the social and family courts are also courts where women are outnumbered men. And for example, in Pakistan, most of the family law courts judges are women. And on the occasion of the first International Day of Women Judges, you wrote a compelling piece for our office UN Agora blog, reflecting on the work that still needs to be done to improve gender equality around the world. But the Supreme Court of New Zealand has achieved an equal representation between women and men. So, drawing on your own country experience, what else could be done by governments to avoid replicating those stereotypes and ascribing women judges to courts different from those socially oriented? And in your opinion, how could governments create fair and equal opportunities for women to serve in high-level tribunals?
Thank you very much for inviting me, and it is an honour to share the panel with the Special Rapporteur and my friend and colleague, Justice Ayesha Malik from Pakistan. I also thank the organisers for holding a panel on this very important topic. It is, of course, very significant that the Supreme Court of New Zealand has equal representation of women and men. And this is even more significant because the Chief Justice, the head of the Supreme Court, and indeed the head of the New Zealand judiciary, is a woman. And what is more, the previous Chief Justice that she replaced was also a woman. Women are and have also been heads of bench of many of the other courts in New Zealand's court hierarchy. In fact, I think there's only about one that hasn't had a woman head. That an equal number of women as men are in New Zealand's highest court, and that women are and have been in leadership positions in the courts is something to be proud of. And it does mean that there are role models for other women judges and for women in the legal profession more generally. It shows too that those responsible for appointments have a belief in gender equality and the value of diversity. So far, so laudable. But I would argue that this is not enough. What needs to happen is for there to be equality at all levels of the court. And because New Zealand is a common law system and judges are appointed from the ranks of practicing lawyers, there also has to be equality in the legal profession more generally. And at the moment, there's no such equality. Overall, the percentage of women in the judiciary is only some 39%. And in the New Zealand Court of Appeal, our second highest court, 80% of the judges are male. Looking at the legal profession, the percentage of partners in large law firms hovers around the 30% mark, as does the percentage of women appearing as lead counsel in the higher courts. Since 2002, only 26 women have been appointed as Queen's Counsel in New Zealand, compared to 84 men. Women do constitute some 60% of in-house lawyers, but that has not been the traditional path to the bench. And all this inequality at the upper levels of the profession is despite the fact that there have been roughly equal numbers of women and men graduating from law schools since 1990, and since 2000, women law graduates have outnumbered male law graduates. So this shows that achieving gender equality is not something that time alone will fix, as has often been argued in the past. And it would be remiss not to mention that there's also a lack of socioeconomic and ethnic diversity in both the legal profession and the judiciary in New Zealand. The legal profession is disproportionately made up of those from affluent backgrounds, and that carries through into the courts. Further, the vast majority of those appointed to the higher courts in New Zealand come from the ranks of commercial barristers. And as our current Chief Justice has said, those who spend 20 years doing work for corporate interests will have experience only of the justice needs and concerns of those clients. In terms of ethnic background, some 80% of the New Zealand judiciary identify as New Zealand European. This is the case also for the legal profession more generally. The percentage of other ethnicities in the judiciary and the legal profession do not reflect their percentage in the population more generally. For example, only some 10% of the profession identify as Māori or Pacifica, and Māori and Pacifica make up about a quarter of the New Zealand population. The authorities in New Zealand are, to be fair, very conscious that more needs to be done to improve diversity in the judiciary. And there are some strategies to improve opportunities for women and minorities in the higher branches of the judiciary. In New Zealand, High Court judges are appointed by our Governor-General on recommendation from the Attorney-General. And over the past decade in particular, all of the Attorney-General, I think, have placed significant emphasis on seeking judicial candidates from a range of legal backgrounds. So while judges have traditionally been appointed from Queen's Counsel, barristers and other court advocates, New Zealand Attorneys General have actively sought candidates from other areas of expertise. I, for example, came from a commercial rather than a litigation background. Seeking out and considering judicial appointees who have had less traditional career backgrounds can improve gender diversity. The New Zealand judicial appointment system is also guided by what they call a commitment to actively promoting diversity in the judiciary without compromising the principle of merit selection. Furthermore, one of the selection criteria is that the judicial candidate is aware of and sensitive to the diversity of modern New Zealand society. So the Attorney General will consider the overall makeup of the judiciary as part of the appointment process to ensure that the courts consist of people with a range of backgrounds, expertise and perspective. So in this way, diversity can and is legitimately considered a part of the application and appointment process. The New Zealand Heads of Bench also recently formed a Judicial Diversity Committee with the goal of improving diversity in New Zealand courts. And as part of this initiative, the committee conducted a survey in October 2021, which recorded the gender, ethnicity, sexuality, family backgrounds, religion, professional backgrounds, and disabilities of those serving as judges. And the committee recognised that we need more accurate data to understand exactly who is in the judiciary and therefore where changes need to be made in the future. And we await their further recommendations with great interest. Starting with the survey, as they did, is a very good start. It's important that countries and international organisations continue to measure progress in this area because it's impossible to create effective policies to improve gender diversity without first understanding the current makeup of the judiciary. And I think what's needed is a comprehensive and multifaceted approach to the issue involving a range of initiatives. And this will be the most successful in creating long-term sustainable change. So one issue is removing barriers for women in the judiciary. Initiatives like job sharing, adequate maternity leave and more flexible working arrangements can enable more women to undertake judicial roles. We also need to tackle discrimination, bias and stereotyping. There's a significant body of research into women in the workplace which demonstrates that women generally are assessed more harshly in job applications and held to higher standards than men. Training targeted at those appointing judges can ensure that women are not unfairly overlooked in appointment processes, and judicial education can also be helpful in creating inclusive workspace environments. Targets and quotas can be particularly helpful, as mentioned in the report. Targets involve setting goals as to the number of female and minority judges, whereas quotas require a certain number, and quotas can be controversial. And there are concerns that they might lead to less qualified candidates. In response, I'd argue that representative judiciaries are just better judiciaries, and I think the research bears that out. Furthermore, I think we do need to challenge our concept of merit. Currently, that's defined by the already dominant, predominantly male group, and it can exclude women and minorities where their qualifications, experience and skills are not valued by the current holders of power, and quotas and target can help shift that. And it should be acknowledged that many of the barriers facing women and minorities in the judiciary reflect structural inequities in the legal profession and society more generally. So if we're ever going to truly reach the goal of equal representation of men and women on all courts, those underlying inequities must be addressed. So we need to invest in girls' education and counter harmful stereotypes from childhood onwards. We need to provide women with resources and support so that motherhood does not bar women from having successful careers. And we need to acknowledge and address the unequal opportunities available to people with different socioeconomic and ethnic backgrounds. Thank you.
Thank you very much, Justice Glazebrook, for providing further thoughts and identifying, for example, additional barriers to be addressed for the governments in order for them to keep increasing gender parity in the judiciaries. As well, thank you so much for sharing with all of us the actions that New Zealand has taken in order to create better conditions for women judges to thrive in their profession. So now let's move on and continue this conversation with Honorable Justice Ayesha Malik of the Supreme Court of Pakistan. Justice Malik, you made history in January this year when you were sworn in as the first female judge on Pakistan's Supreme Court, and where You are currently serving alongside 16 men. Both the Pakistan legal profession and some articles in the media consider your appointment as an important step towards improving gender diversity in the judiciary in Pakistan, where women seemingly account for only 17% of judges overall and just under 4% in higher courts. However, disparities are structural in Pakistan, and perhaps it requires more investment in women in the legal profession. So, based on your own experience, what are the structural disparities you experience in the judicial appointment process, and what would be your strategic advice to other female judges to continue accessing higher and influential positions within the judiciary in your country?
Thank you, Monica, and thank you for having me on this discussion. It's an honor to be meeting even on Zoom with the Special UN Rapporteur and my friend Justice Glazebrook. So yes, this year has been eventful in terms of the first appointment after 75 years to the Supreme Court, and it's been an adventurous process, because if you have been following the news, you would have seen that from last year, September, there was this whole debate on what motivates this appointment. Is it the gender? Is it the merit? And so you have this entire debate going on whether the gender is motivating the appointment or whether it is the merit. And I'll just come to this point because I think this is an important aspect of the appointment process which needs to be addressed. So historically, at least in Pakistan, the legal profession is one where women would not easily join and were not really considered appropriate for this profession. However, with time, things have changed and more women have joined this profession as lawyers, as judges, as prosecutors, and you see more and more women doing well in law colleges. You don't see enough women possibly handling their own cases in courts, but you do see that the population of women lawyers has increased. And of course, there are women judges, but certainly not enough. And I say that because in the Supreme Court, as you know, there's only one. We have only 5 women in the high courts out of, say, more than 100 male judges. In the district judiciary, the highest tier is a district and session judge. And throughout the country, there are only 22 women district and session judges. And not each of these 22 women have a district at their command. So they're not even given that top tier position. They're not given the responsibility that goes with it. And I've often questioned this because we have 32 districts in the Punjab, and out of those 36, so maybe 1 is given to a woman, and at the moment maybe 2. So, you know, there's this whole question of how do you rationalize the ratio of 2 to 34 when you could have more women. If there are 4 women district and session judges, then give them all 4 a district, at least so as a start. So yes, I think the first step for us at least is to acknowledge that there is an imbalance and that this imbalance needs to be addressed. Now, so far as the High Court and the Superior Court is concerned, the appointment process is governed by the Constitution, and there is a judicial commission that appoints judges to the High Court as well as to the Supreme Court. And I would say that the biggest issue here is that women generally are just not part of the process. They are not considered. So if they are considering 20 men for 6 or 7 positions in the High Court, in the last several years, none have been women. So they're just not considered. There's no, I would say, visibility of the women lawyers who are there. And so they're not included in the process. And that, I think, is a challenge. So far as the Supreme Court is concerned, I think it's interesting to consider why it's taken 75 years to appoint a woman to the Supreme Court. And even after that, even at this point, why is there so much emphasis on the debate as to whether it's the gender that's motivating the appointment or whether it's merit that's motivating the appointment? I would like to say for myself that I would hope that it's a bit of both. I mean, I think my merit it should be considered deserving for the appointment. I was to be considered, then my merit should have, I mean, I am one who can be considered. And the gender is also important to be considered, because if you have a woman judge who is a potential candidate, then in the very least, you should be considering the woman judge who is a candidate for the position. So when we see this appointment process and you see representation vis-a-vis the population, 50% of the population of Pakistan is women. And that would mean that 50% of the litigants coming to court are women, and women come on a variety of issues to the courts, and not just family issues and not just violence issues. There are, property rights and job issues and other things that bring them to the court. So the question is that, is the gender perspective well represented in the courts? Is there enough visibility of women judges who are working in the courts and not just in the family courts, as you said, the women courts? So I think that aspect is has to be dealt with, and this I'll just come to that as well. But some of the barriers that are there is, one is, just the mindset. There are cultural issues. There are presumptions that generally go against women. People still don't have that comfort and that trust where women are concerned. They still associate women with certain given roles. However, I would like to say that this position is changing, and there are people within the system who are making an effort that go against women, and there is an effort to make women more inclusive. But the question is that you just need to is not sufficient. There are also other issues, because since these are systems designed by men, primarily men, so one has really thought about what it means to have women in the space. And so you have problems of residences, you have problems of chambers, you have problems of washrooms, you have problems with transfer policies, you have problems of how to manage single women, how to manage young women who are in the profession, as well as older women who may have to take care of family or parents. These things then, they need to be considered. And I would say this is not about giving special treatment to women. It's just about making sure that the system responds to the need of the people who are working there. And then another problem is that since there are cultural barriers, or there is a mindset about women working, a lot of these women, particularly in the district judiciary, they may not have the same support system and the facilitations that they should have, or that they could have, which enables them to work and to maintain a good work and home balance, and to manage their responsibilities. So they'll still be required to take care of their home in the same manner as they would be if they were not working. And maybe very little exceptions can be made in such cases. Another issue is also the coexistence of men and women when they work together. So because you have people coming from backgrounds where they don't interact as much with men, coexisting as professionals is something that requires mentoring, it requires attention, and it means that you have to induct the professional standards into the profession so that people know how to coexist. And that means you have to know how to address the women there, you have to know how to talk when women are in the room, and it shouldn't create an awkwardness either for the woman or for the man. So we still have concerns about how women judges are addressed. You still have concerns about whether they're given the same kind of respect as the male judges. And so this narrative, this conversation continues. So At the same time, while these barriers are there, there is an effort being made to become more inclusive. And because this is a slow process, so one has to keep working at it, and one has to keep trying to keep the narrative going and trying to make sure that you create the space which is more comfortable and accommodates women. In this, your question was of what and what I would advise to women judges. So I'd like to explain that through an effort that was made. As I was the only woman in the High Court for some time, I realized that there are a lot of issues that need to be highlighted, and there should be a forum where the women judges should be able to highlight their issues. So we hosted, the High Court hosted the first Women Judges Conference. And in that conference, the women working in the district judiciary were given an opportunity to highlight their issues, from washrooms to transfer policies to harassment issues, to whatever they felt that were barriers in the system which prevented other women from joining, and which also prevented them from making this a more popular profession where women are concerned. This conference was followed by a second and a third conference where we were able to bring to the forefront the discussion on what is the role of women judges and how women judges can help bring the gender perspective into the discussion, and how they can use gender neutral language in their judgments, which will all help change the mindset and help change the narrative. So we help these judges discuss their role and tell them, encourage them to adopt means to help improving access to justice. And most importantly, I would say, to become role models in themselves. It's a small community, and they can help each other, and they can become the role models for others. And as I often say to them, that, you have to keep opening the doors and then leave the doors open so that more women will follow. What these conferences led to was an important discussion on the systems, the processes, and how we can induct the gender perspective in these processes. So two things are important. Training. We started actually training judges on gender sensitivity, which is vital, because you need to show and share with colleagues how to be more sensitive to the gender, not only in the way you speak, but in the way court is addressed, for the staff, for the litigant, and so on. And it also then brought to our attention that, the system it may not be very conducive to female litigants, particularly in gender-based violence cases. And so we introduced the gender-based violence courts, which actually protected the victim in several ways and made it a more comfortable courtroom where she was able to narrate her story without feeling harassed and without feeling that she still is being abused in some manner or the other. So basically, these are all, I would say, these are all challenges. And you have to learn to face the challenges and capitalize on the opportunities. And this means that women judges have to make their presence felt. And as has already been said, women judges, like women in many professions, just have to work harder. And sometimes, you're judged at a higher standard. But then if that is the case, one has to keep endeavoring to try and create space by at least showing that we are there, and that we are there to make a difference, and that we are there because we should be there. So women judges need to help change the narrative. They need to voice the issues out, and I think they can use their judgments to make a difference. I'm a big supporter of gender neutral language, and I make a lot of effort to prevent myself from constantly referring to everything as he in my judgments. It's just, I think it's the way we think. And now, I try to make a concerted effort to stop saying he, because that only perpetuates the narrative that, the system is of men and should be decided, and all decisions are to be taken by men. So having said that, I would say that this is my 10th year as a judge, And I have learned that this is an ongoing process. You have to keep at it, and you have to keep nudging and reminding people that you are there. In the Supreme Court, I believe that, in the High Court, I was at number 4 in seniority. I had spent 10 years in the High Court. So I believe I'd kind of made my presence felt. And so the challenge now is to restart the same thing in the Supreme Court, so that the concept of the gender perspective and inclusivity and diversity is no longer the exception. And I would like to see that with time, the debate on why a woman is being appointed to the Supreme Court is no longer that it's about the gender, but it's all about the merit. So if a woman deserves to be appointed, she should be appointed. So I hope I've answered your questions.
Thank you very much. Of course you did, Justice Malik, and thank you for your insights and assessment about the current situation in Pakistan, and for highlighting the importance of addressing the challenge of gender imbalance in your country. In my opinion, it's also vital to continue discussing about those cultural factors that have impeded women to participate in public life. So now I would like to go back to Mr. García-Sayán. Diego, while acknowledging the progress made by several states in promoting gender equality in the judicial systems, in your report you also warn that the development and implementation of gender equality policies have been uneven and inconsistent, and the results, although substantial, are still insufficient. So my question here is, what else could be done by the United Nations, and in particularly from state members, towards the achievement of Sustainable Development Goals 5 and 16 to address the global responsibility of states towards gender equality and women's representation in public institutions such as the judiciary and the prosecutorial offices?
Thank you, Monica. Very relevant and crucial question. Because I can share my experience. When I was presenting this report in the General Assembly, there were a lot of presentations supporting my views, supporting the proposals I had just made from European Union, United States, China, Russian Federation, Saudi Arabia, some Latin American countries. So it was a kind of weird context in which apparently everybody agreed that these goals, 50% women, should be achieved by 2030. I am not suggesting that all of them were being irresponsible or lying, but perhaps they were in the goodwill sharing this view, which had the UN language, the UN principles. But at the end of the day, these changes that we need to promote and support and encourage will not be made by diplomats in the UN, but they will be made by politicians, by judges, by civil society inside our countries. No? And so what I think would be fantastic is that from the United Nations, there should be a more close follow-up of this evolution, of this process, asking the governments through the diplomats to share this information, what steps they are taking, not what general views they share about the gender equality, but what are the figures in which you can say, well, finally, there's a women judge in the Pakistani High Court. That's a very concrete step. So a way through which the state should be required to present annual or yearly reports precising with figures their advances, their progresses, not general theory about how they support the rights of women. And of course, I think that the judges' organization can continue to play a fantastic role in this area, advancing in sharing, in organizing all this information so that there is increased awareness for this matter. I have had big difficulty to have all this views organizing a system. There are very few world judges organization. So I think that this kind of interaction between what is being done through diplomats or asked through diplomats, at the end of the day, what happens inside the countries is absolutely crucial. And perhaps the last thing is, and I'm sure Justice Malik can share with us her experience. How can this traditional view that prevails in members of high courts in the world, how this traditional view in which not necessarily openly, but this kind of reluctance to promote the role of women in that high post can be eventually changed? What have been the clues to allow that evolution in a country like Pakistan? I would like to hear from Justice Malik that what changed in the mentality in the high courts and how this change occurred. That is a very important thing. I am not in position to answer that question for my country. The key question was that when Chief Justice women assume a post, she made a change. so that's an easier response. But that will be a thing in which, at the end of the day, turning what to be local and national decisions in the UN as only a kind of promotion, a role, which is at the end of the day what a modest special rapporteur can do with his or her report. Thank you, Monica.
Thank you, Diego, for providing further guidelines for the United Nations and the state members' engagement in an effective implementation of the SDGs 5 and 16. Justice Glazebrook, following a similar concern about further actions that need to be taken to advocate for women judges around the world, how could the International Association of Women Judges assist or support the implementation of the UN rapporteur's recommendations? And how could the United Nations and the International Association of Women Judges continue building synergies to expand women's leadership in the judiciary worldwide? You are muted, Justice Glazebrook.
I was very, very pleased to read in the report of the Special Rapporteur a recommendation about setting up or that countries encourage the creation of Association of Women Judges. And I was even more pleased to hear the Special Rapporteur in his summary of the 7 recommendations reiterate that. The International Association of Women Judges, or IAWJ as we call it, believes very strongly in the power of women judges associations to effect change at the national level. And we also consider that the IAWJ as an umbrella and global association has a crucial role to play in achieving gender equality in the judiciary more generally. And we see ourselves as well placed to promote diversity because we see diversity in the organisation itself as one of our strengths. The IAWJ has over 6,500 members from more than 100 countries and territories around the world, and from every level of court and tribunal, and from both civil and common law countries. Membership is deliberately wide to encourage diversity and inclusiveness. So we don't stand on hierarchy, and all women judges, no matter what jurisdiction, can join the IAWJ. And we also recognise and welcome quasi-judicial officers. Indeed, all judges and quasi-judicial officers of all genders are welcome to join the IAWJ. And we welcome also as non-voting members any other person who supports our goals. So our vision is for a world where gender equality, support and respect for human rights and inclusive justice systems are the norm. And our mission is to support and empower our global network of women judges to advance gender equality and human rights. And our core values are to recognise the fundamental importance of gender equality, to use human rights laws as a vehicle to integrate women into society, to ensure access to equal justice for everyone, to respect and value cultural diversity, and to exercise judicial leadership boldly, independently, and creatively. So our aims are not merely the equality of women in the judiciary, but the equality of women generally, and we think the two are very much tied together. The IAWJ provides a critical and overarching support network for women judges. So both individual judges and fledgling women judges associations can find mentors among the membership of the IAWJ. And it's particularly valuable, I think, in countries where women are traditionally underrepresented in the judiciary and who therefore have fewer female role models to take guidance from. But of course, learning from these relationships is always two-way. Swapping ideas always enriches. So alongside mentorship, the IAWJ is well placed to provide much needed companionship for judges around the world. Women often feel outsiders in the male-dominated professions. They face unique barriers to their career development, as we've talked about. And in some jurisdictions, women judges have very few female colleagues to discuss these experiences with. So the IAWJ provides a safe place for women judges to come together and receive support. We also run education programs for judges, but making sure always that these are adapted to the particular jurisdiction, that they are judge-led, and that they fit within the values of the IAWJ, and in particular in relation to the promotion of international human rights norms. So we've done training programs, for example, on issues related specifically to women or mainly to women, such as domestic violence, trafficking of persons, and sextortion. We also encourage the development of women leaders. So the Global Leadership of Women project, better known as GLOW, provides an example that the IAW contributed to on the facilitation of mentoring and leadership. So we had women judges from a number of jurisdictions around the world, including Cameroon, Ghana, Nigeria, Bangladesh, India, and Nepal, meet with women judges from high-level international tribunals who acted as mentors. And they held collaborative conferences discussing their experiences, sharing ideas, and building leadership skills. And as I say, that would have been a two-way relationship, very much so. So as a result, various of the national organisations embarked on various projects to look at gendered issues in their own communities. And one particularly notable project was the work of the Ghanaian chapter of the IAWJ, because they organised a meeting with the traditional women leaders in their communities known as the Queen Mothers. And these women play a large role in resolving domestic and sexual violence cases. And at the meeting, they discussed all of these issues and also discussed the Ghanaian legal framework, which of course was not necessarily known to the Queen Mothers in detail. And the Queen Mothers apparently left that day feeling empowered in their roles because it gave them the tools needed to initiate conversations on sexual assaults with the children and mothers in their villages. And community-led initiatives like this are probably the best way to ensure culturally appropriate and enduring change. And women judges associations are very important in cultivating leadership at those very grassroots levels. Now, more generally, the report of the Special Rapporteur emphasises that more needs to be done in terms of securing greater equality of women and men in the judiciary, and talks about the appointment and promotion processes. Now, the IAWJ can't itself directly affect individual judicial appointments in individual countries, but we can encourage and influence through advocacy for diversity and through outreach in the running of educational programs and provide these development and leadership opportunities for women judges. In respect of the gender bias that's mentioned in the Special Rapporteur's report, it's especially important that gender equality is in the justice system because judges can't effectively and fairly apply the law without understanding the communities in which they operate and the diverse lives of those who come before them. And the diverse judiciary also helps ensure the legitimacy of the courts. So it's very important that we keep this issue on the international agenda, and the main thing is visibility and avoiding complacency. So we need to keep sending the message that women must be present in all levels of the judiciary. And one of the important initiatives in achieving visibility, I think, is the International Day of Women Judges, because then we can totally concentrate on women judges at least one day of the year. It seems to me that one prerequisite to improving the position is to get a totally accurate picture of women in the justice system around the world, including in any customary and informal justice systems. Then progress can be measured properly. And it's a huge task, and one where the IAWJ and the UN could collaborate. And I support totally the idea that states should be required to present annual reports on their progress, because only then can they actually have a total incentive to operate and to talk the talk, walk the talk, as they say. I think also actively seeking the views, experiences and ideas of women and minority judges also enables better solutions. An example of this is the work of the International Commission of Women Jurists in 2014 report, because they collected thoughts and opinions from a range of women judges and senior women lawyers around the world. And it provides an invaluable insight into the barriers women face in their careers. And some of the comments in the report are quite heartbreaking, especially as I suspect they're still happening today. So one judge said, in many ways, the authorities treated both male and female judges in the same way. They oppressed one and they oppressed the other, persecuted one and persecuted the other. But when they wanted to subjugate and intimidate judges, they would start with the women judges. They moved women judges away from capitals and away from their families and children. Women judges maintained their resolve, but they paid a price. And that's heartbreaking because it speaks of the fragility of judicial independence, but also the subtle ways in which it can be attacked, as well as the particularly vulnerable position of women judges. And Afghanistan reminds us of how fragile progress can be. Since the Taliban reached Kabul, they've effectively annihilated the profession of women judge. Women judging men as anathema to the Taliban view of the world. And one of the judges' withdrawal had been confirmed. Things changed for her. In her court's monthly meeting in July, that was before they reached, two of the judges, her colleagues, stood up and said, Islam and Sharia law does not allow a woman to be judge, and we won't stay in the same room with you. She was totally shocked and frightened. She couldn't believe it. These were her colleagues. These are people she'd been working with. And she wondered how they'd changed overnight from judge to Taliban. Their behaviour was a clear warning for her, leave the job and save your life. And of course, once the Taliban did reach Kabul, her position and the position of women judges became untenable, and the only choice was to leave if they could. And we've been helping our Afghan colleagues since August last year. We could not have felt we were true to our values if we'd not stepped up to help. Thank you.
Thank you so much, Justice Glazebrook, for highlighting additional actions towards implementation of this report, but also for proposing areas where coordinated efforts could be achieved along with the United Nations in this relevant area. Justice Malik, while stressing the importance of gender parity for the equal and effective protection of human rights, the Special Rapporteur also underlines in these reports that the elimination of discrimination against women will require systemic changes in social structures, and he calls for a stronger political will. So what kind of actions or initiatives could be implemented at the national level to open access for more women in higher courts? And in addition, for example, of creating equal opportunities by setting up strong legal frameworks, which other institutions and actors in society have a role to play in this relevant endeavor?
So when we're talking about what can be done at a national level, there are two ways that I can think of answering the question. So far as legislation is concerned, of course, that's for the legislator to see where the changes can be made. But even in that case, for me, the concern is that when you start legislating on women's participation, suddenly the need to make reserve seats or quotas arises, and I think that would be regressing from where we are today if we were to go back to saying there should be a quota for women in the courts, because that sort of reduces the credibility of the appointment when you say that you've been appointed on a given quota. So I think if we were to look at the existing system, it's really all about policy. It's about policy, and it's about the enforcement of that policy. Within the judiciary, there is a policy-making body which is headed by the Chief Justice of Pakistan, and so he is in a position to create inclusive policies on the advice of his Chief Justices and other members, and he's also in a position to stress on certain aspects of certain things that would make the system more responsive and inclusive. So, for example, if it was something that I would to suggest, I would say that there are two things that need to be done almost immediately. One is to make training of gender sensitivity training and dealing in gender-based violence cases, dealing with issues pertaining to women. You need training, dealing with people, vulnerable people, dealing with transgenders. We have a small population of transgenders. They are recognized as the third gender, so far as their identity is concerned. But we don't have the vocabulary, we don't have the mannerism of how to address them, even when we are addressing them in judgments. And I think that training is vital. Gender sensitivity training is vital because it does two things. One, it brings to the table the discussion. So it allows judges in particular to talk about things that whatever's on their mind, to bring their mindset into onto the table, and it allows people to question that mindset. It allows people to give alternates and to suggest how a particular mindset is really stereotyping or discriminatory, or that is just perpetuating an image which is not necessarily there. The second, I think that is something that the Special Rapporteur also mentioned, is data. If you are not collecting data, and the data that you collect does not give you any information about gender, you really don't know what you're targeting, and you don't know what your challenges are and what you need to address. So data, it is vital. And one of the things I did while in the High Court was to include the gender requirements in the data that we were collecting from the district. So how many women litigants are there? What are the cases that women litigants are bringing? How many lawyers are women who are representing women? How many women are representing men? What is the outcome of the decisions that are being made in, so far as women are concerned? So a database is vital because that allows you to see what areas need attention. And then from that, you need to start reviewing policies and practices, particularly related to the code, so that you can make the processes more gender responsive. And all of this can be done with little intervention of legislation and more intervention of policies and rules, which the judiciary can do within the framework of what it is empowered to do. So while all these suggestions are being made, again, we use the Women Judges Conference as a platform to put out the ideas. And we did get a good response because we did get a transfer policy which was a little more gender responsive. And we also got a gender policy which was to help women judges settle into districts where there was no proper arrangements made to them. For them, I got to chair the first Women Judges Committee, which basically looked at issues pertaining to women judges, right from housing to harassment issues. And I found that that body was a good body to use as a mentoring exercise, where you can mentor judges as well and help them see where the problems are, whether it's just work related or whether, again, you have to see the background from where even the women are coming. They may not necessarily have the exposure to give them that professional, to give them the professional requirements or to the training that they need. So I would stress on training, and I would stress on data. These would be my two priorities. From there, I would move to reviewing policies and making the system more gender responsive. I think it's important to recognize and acknowledge that there is a gender perspective, and the gender perspective is not about women looking at women issues. The gender perspective is part of the process. When you are adjudicating on rights and issues which will affect women, you can't always have, with all due respect to the systems, you can't have men deciding everything for women. You need the gender perspective. You need women to participate, and you need to recognize the fact that if you are deficient, you need to include women in the decision-making processes. So you need to find out ways in which these women can be included in the policy making, in the decision making, while looking at systems and processes. Just to share an experience, of why training and addressing the mindset is important, that while working on the virginity testing case, the two-finger test case, I realized that the thinking of the system is so ingrained that even the women judges were thinking like the system was thinking. So even women judges were relying on the two-finger test in rape cases. And when I would ask, and I just simply confronted them and say, what is this establishing? A lot of them were not sure of how to respond. And that's because the thought process is so ingrained and perpetuated by the way we write, by the way we speak, and just by the thinking that prevails over the system, that women are compelled to think the way the system is telling them to think. And of course, it takes a woman to call out the prejudice as well. But the fact is that I think training in countries like Pakistan are important, because training gives people the opportunity to speak out, to say what's on their mind, and it gives you the opportunity to question the mindset, to question the stereotype thinking that does perpetuate in the system. In this, the IAWJ has played a very positive role in helping us. We do not have an association of women judges, but they have helped us. They've participated in 2 conferences. They've brought their experiences. They shared their experiences with us. They visited our courtrooms and they gave their input, which I must say was helpful. And sometimes, the experiences of a body such as the IAWJ, it's easier for them to say a lot of things that people here may hesitate to say, or that women may hesitate to say. So the IAWJ has not only had a great impact on me, but it has impacted our system. I attended a conference when I was first elevated to the High Court in San Diego. And at that time, I went with so many questions in my mind that I'm the only woman there. How am I supposed to behave? What is the accepted behavior pattern? How should I dress? How should I think? And it's when I met this huge community of women judges that I realized that I am who I am, and I should be who I am. And I don't need to change my thinking process. I need to make the system respond to my being there. And so I think it's important that this kind of a narrative continues. And to answer the question asked about how the thinking is changing, or whether in the appointment process the thinking is changing, I would say it's changing, but it's changing at a very slow pace. We need to be more inclusive. We need to make a conscious effort to consider women for appointments. It's not they shouldn't be ousted from the process. At this stage, I would say that maybe, you know, in every process, a woman is not appointed, but at least they should be considered. You have to start including them. You have to start motivating them. By excluding women totally from the process, you send out a very bad message. You send out a message that says that, you know, you're not good enough for the system. You're part of the system, but you're just not good enough for us to include you at a post where you should be there. So I think this is important. It's a slow process. I see change and I see the will for change, but it's a slow process, and we have to look for ways to improve it. Which means, again, I go back to training, I go back to discussion, and I believe that the more this issue is debated and discussed, the more we can tackle the challenges of the mindset and try and reduce the stereotyping. So one of the things we discussed in these conferences was the use of language and how language perpetuates stereotype and discrimination. And I can happily say that when we pointed this out through judgments, and we showed that how judgments, you know, use languages which perpetuates a thinking, a lot of our male colleagues were actually surprised that they hadn't thought about this, that they constantly refer to things in a particular way, and they never really thought that this is perpetuating a wrong way of thinking. And the more you perpetuate this thinking, the more you discourage the ability of women becoming a part of the system. So, you know, I take my own example. I'm often asked whether I specialize in family cases, like you said, you know, women's court. I'm often asked whether I go home early. I'm often asked, you know, whether what kind of cases I do. Are they all related to women? That's just not the case. That's just not the case. But I look at this as a positive thing. It's a good thing that people feel that they can now ask, because it gives me the opportunity to respond. And so I encourage this because it gives me the ability to respond positively and nudge people in the other direction. So, so I think that collecting data, training, reviewing policies, consciously including women in the system is the way forward. And as we move on, hopefully we can give some speed to this very slow process of including women in our system, in our judicial system. Thank you.
Thank you so much, Justice Malik. It's undeniable the role of Congress to craft legislation with the gender perspective that you have suggested today, but also based on current data. But also I do believe like the enforcement of those inclusive policies become vital to promote better access for women in the judiciary. So now I would like to ask to our audience if you have any questions for our panelists. So if there are no further questions, I would like to give the floor to Mr. García-Sayán for his closing remarks, please.
Thank you, Monica. Really, I have enjoyed both presentation, and thank you, Justice Glazebrook. Thank you, Justice Malik. There are the key concepts being expressed very, very clearly. I recognize, for instance, I am not making a summary, but crucial aspect first, maintaining this matter in the international agenda, maintaining it in the UN, in other spheres, in the European Union, in the Inter-American system, in whatever places in which this matter can be placed and mentioned, with periodic and systematic reports. What is going on? What are the progresses? What are the setbacks and challenges? That is very important. There is no international regulation that obliges countries to do so, but perhaps if countries don't make official reports, perhaps a gathering in which the International Association of Judges, international bar associations which are committed with this context, like an International Bar Association. They have a human rights area there. Maintain this as a permanent thing in which awareness, information, progresses, and challenges are being mentioned with figures. So what the Justice Malik was mentioning, among many other relevant things, of course, is absolutely crucial. We need data, very precise data. The data I haven't had to prepare this report. I have to send a questionnaire. Somebody responded, others none. And we had these gatherings, which obviously are in a way biased. But there some people were invited, some people presented, many others that they don't share perhaps the same view. They were not present in this gathering. So I think this dialogue with this consultation is absolutely crucial. And I would say, last but not least, that it's important to involve in all this process in which gender perspective shouldn't be, as has been mentioned today, shouldn't be a matter only of women. Gender perspective is a matter of a concern, should be a concern of the society as a whole, because it's not a question of women against men. It's a question of that society must organize itself in a way in which gender perspective must be part of it, the way in which it is organized, the way in which decisions are taken. I have had some experience, not as a local judge, but as an international judge, and I have really enjoyed myself and learned a lot with colleagues, with women judges, colleagues, in the way in which gender perspective is really a big benefit, having these women, but not always. There are some women judges, women lawyers, in which they are quite distant from a gender perspective. That happens. And of course, you find men that do have a gender perspective. So I think that the substance of the idea, what does a gender perspective means, is a way in which we need much more systematic, not information there we have a lot, but views, examples, in a way in which we can, for instance, and I finish with this, two ideas, no? Why don't we think first, an annual report with this data? Second, an annual price, no, for a person, woman, man, transgender, whatever, that in a way personalizes things, being important things being done, promoted regarding gender perspective and the equal participation of women in high-ranking posts in the judiciary. I think that person should be mentioned, should be in a way promoted, no? as good examples to follow. So at the end of the day, this is my last year as a special rapporteur, so I would fantastically be able to support your activities since I leave this post, and then of course let me express my deep appreciation for Mónica Castillejo, to what all she has been done to support not only this report but many other reports, and of course to Andrea Osheimer and Konrad Adenauer Stiftung, whose support has been absolutely crucial in a context in which the institutional support coming from the UN is not always a relevant and efficient one. So thank you very much. And again, I have enjoyed this presentation, what you have said and what you have proposed, Justice Hazelbrook and Justice Kayaka, absolutely central. Thank you very much.
Thank you very much, Diego. And it was also our great honor to support your mandate over the past years. And we have reached the end of our panel discussion today. And on behalf of CAS New York, I would like to take the opportunity to thank our panelists and all of you for joining us today. And I wish you a wonderful rest of your day. And we will see you next time. Thank you very much.